Hello, everybody, and welcome to Empire State Weekly. I'm Tim Lake in Albany. Well, we knew it was bound to happen, and now federal lawsuits have been filed over two of New York's most controversial new laws. Erie County Clerk Mickey Kearns has filed a lawsuit in federal court in Buffalo opposing the new Green Light Law, which will allow undocumented immigrants to get their driver's license this fall here in New York State. Now, Kearns wants a court injunction to block the law from taking effect until the case can be heard. He says forcing county clerks to grant licenses to illegal immigrants violates federal law. But state Democratic leaders say the law was carefully crafted to withstand a legal challenge. And the other lawsuit, 55 parents are now suing over a change in state law that removes their religious exemption over required childhood vaccinations. Their attorneys say state lawmakers violated parents' religious rights when they repealed the non-medical exemption last month. But the Supreme Court ruled more than a century ago that states do have the right to enforce mandatory vaccination rules if the public health is at risk. And joining us now to discuss both of these new lawsuits is New York Law Journal reporter Dan Clark and, of course, our weekly contributor, WGY Radio news anchor Diane Donato. Thank you, Dan, for joining us here on Empire State Weekly.
Thanks for having me.
So we anticipated these legal challenges. Just to give us a brief explanation of the grounds of the Buffalo County Clerk's lawsuit, and do you think it's valid? Do you think he's got a chance?
Right, so this is Mickey Kearns. He's the Erie County Clerk. He was in the State Assembly, you might remember. He took the clerkship, I think, last year. So he's suing because he's saying that he's kind of in between a rock and a hard place on this. On the one hand, if he enforces it, it's a felony to conceal any immigrant in the country. That's a federal crime, is what he's arguing, is that he could be charged by federal prosecutors with this. On the other hand, if he does not enforce it, the governor has the power to remove any county clerk in the state who doesn't enforce a state law. So he's saying, I could either be charged with a crime by federal prosecutors or I could be removed from office. This is an impossible situation that I've been put in. And he doesn't support the law. He believes that the law giving undocumented immigrants driver's licenses is unconstitutional itself.
So same thing for every other county clerk across New York State? They'd be in the same boat?
Yeah, they'd be in the same boat if they choose not to enforce the law. I mean, it could be argued that even if they choose to enforce the law, they may be breaking federal law. That could be argued by Mickey Kearns. But the clerks who do that do choose to enforce the law, they won't really have as much of a problem in their view.
And there is an association of this group that could maybe speak together as one. Do you see that happening?
The county clerks, you mean?
Right.
I don't see it happening everywhere. There's Sheldon Nofel from the Monroe County. She's the Monroe County executive. She could join on to the federal lawsuit with Mickey Kearns because it's in the Western District of New York, the federal court.
And Rensselaer County.
In Rensselaer County, it's in the Northern District. So he may not have the standing or the jurisdiction to join on to that lawsuit. The other thing is they could bring this lawsuit in state court. Some of them could, and they may have a better chance there depending on what judge they go in front of. So there are a myriad of options, and certainly they have a lot of them going forward.
So explain this to us, and you work for the New York Law Journal, so you understand this better than most people. Who defends this, and does this come back around to Attorney General Tish James, who has said, just in general terms, that it's constitutional and she could defend it?
Right, so the lawsuit is targeted. The defendants in it are the state of New York, Governor Andrew Cuomo, and Letitia James, the Attorney General, as you said. Anytime that the state is sued or the governor is sued, it's Tish James's office that's going to be doing the defending. So she said before when the law passed, she said, I think it's constitutional. Our office has interpreted it as constitutional. We'll defend it in court. When I asked them earlier this week when the lawsuit was filed if they held the same thoughts based on seeing Mickey Kearns' lawsuit and seeing the arguments that he's going to make, they still said, we think that it's constitutional. We're going to defend it. We don't see any problem here. So it's going to come down to them.
Now, this is going on in other states. I think about a dozen states allow people who do not have documentation to get licenses. And there have been challenges in those other states. How has it gone there?
So I'm not sure about the county clerk challenges in the other states. I will say California's in the middle of litigation between the federal government over maybe getting the information of these undocumented immigrants out of the California DMV system. California is saying we don't want you to have that information because it'll expose our residents who may be undocumented to deportation, and they don't want that.
And that's a concern now raised here in New York as
Exactly.
well.
The governor has said time and time again that the federal government could do this under this law as well, except supporters of the bill have pointed to a spot where In order to get that information, you have to have either a subpoena, a judicial warrant, or some sort of order by a judge that would allow you to actually obtain that information. You can't just act as an ICE officer or a member of the federal government and ask for it and get it from the state.
What kind of a timeline do you see this playing out in the courts through?
It's difficult to say, but the law goes into effect in December. Usually litigation like this will take years and years and years to go on. I mean, laws like this that are challenged on a constitutional basis could take up to 2 to 3 years to have some kind of resolution. So what I would foresee happening is they filed the lawsuit. The state now has to file a motion to dismiss that lawsuit. Then they'll do back and forth paper filings. They may have a hearing on that motion before the judge, and then the judge will make a ruling. Whether that will happen soon is anybody's guess, but if it doesn't, the plaintiffs, Mickey Kearns, could also file for a preliminary injunction to stop that law from going into effect.
So I guess you anticipate this won't happen in December, this licensing issue.
I would be surprised.
All right. Well, the other big issue has been this other lawsuit that many people were also anticipating, where the group of parents have gotten together and they're suing over the removal of the religious exemption in the vaccination bill. Was this a surprise to see this lawsuit?
It was a little bit of a surprise to see the attorneys on the lawsuit. It's Michael Sussman and it's Robert F. Kennedy Jr., both very prominent lawyers in the state, very well known. So their argument is that it's a religious argument. They're saying that it's a freedom of speech argument. It's under the First Amendment. These people, all these 55 families, are plaintiffs that have previously gotten a religious exemption to these vaccines for their children. So they're saying this system has worked for us before, and we want it to continue working for us. This law is unconstitutional, is what they're saying, especially because these kids have to get an education in New York State one way or another. It's state law. It's required under state law. They either have to go to school, they have to go to private school, they have to be homeschooled. So they're saying, we have jobs. We can't take our kids out of school and homeschool them, but we also don't want them to get vaccinated. So it's kind of like the Green Light bill. These parents are saying they're in between two places and this is an impossible situation for them.
We saw as the session was going on that there were some legislators who went on the record and said, listen, personally I'm in favor of every vaccination under the sun, but I am concerned about the religious exemption. I am concerned about personal choice. Now we're starting to see some movement, and this is coalescing into more of a movement. Do we see any groups like the ACLU getting involved?
That is an excellent question. I would not be surprised to see them support some kind of amicus brief, which is a friend of the court brief, which is when they basically write to the court and say, this is our position on this as a civil rights group, and this is what we want you to know about this. So I wouldn't be surprised. I think that would be a fascinating development to see, it, even if the New York Civil Liberties Union got involved in it.
So Dan, one final point on this. It's our understanding that the courts have traditionally ruled on issues like this in the past, and in fact one issue with vaccinations, and they seem to side on helping public safety, benefiting all of us when it comes to our personal public health.
Right.
So what grounds do they have to win this suit if the courts in the past have typically sided for the majority?
You know, there's never any harm in bringing a lawsuit and seeing if it can be reversed by a higher court. We saw that with Roe v. Wade. People are afraid that that's going to be reversed. So one of the cases here in question is from 100 years ago, where the Court of Appeals, the state's highest court, basically said that these vaccination laws are constitutional.
To benefit
the state can
everybody.
do it. Yeah, but this is 100 years later. Maybe this new panel of 7 judges on the state's highest court may interpret the law differently and may feel differently about that. And that's what, I mean, courts do that all the time. They interpret laws differently than a previous court. So it'll be really interesting to see if this is held up by the state's highest court, if it gets to that point, or if they go in a different direction. I wouldn't be surprised if at some point along the way this law is struck down in some capacity.
All right.
Well, real quickly, though, one thing is schools are on the front line, especially a lot of private schools. So what will they be doing? They're waiting to see if it's in limbo, but are they going to have to proceed with not allowing students to enroll for September?
Legally, yes. And what is happening right now is the attorneys have filed for a temporary restraining order against the law. That decision is supposed to come soon. If they're not granted that, or even if they are, they're also going to file for a preliminary injunction to try to get that law halted before the school year starts, so the parents that are affected by this don't have to go through that process.
All right, well listen, Dan Clark with the New York Law Journal, thank you very much for being here with us on Empire State Weekly. I know you have articles on both these cases in the Law Journal, and you can read them online.
Please.
Well, coming up, the U.S. women's national soccer team demands equal pay. That has helped New York pass a law to guarantee equal pay for all working women. And if you have a comment or a story idea, let us know about it. You can email Empire State Weekly, and you can find us on Facebook and Twitter. Welcome back, everyone, to Empire State Weekly. I'm Tim Lake in Albany. New York has now expanded an existing law prohibiting gender pay discrimination as a way to close the gender wage gap. The new law makes it illegal to pay someone less based on factors such as race, religion, or gender identity. It also changes a legal standard for pay equity to make it easier for employees to prove discrimination in courts. Now, Governor Cuomo signed the law just before joining the U.S. women's soccer team for a parade in New York City, honoring their World Cup victory. He says he supports the women players demanding equal pay as men players, and that this is a, quote, moment for change in our society.
We are going to break the glass ceiling, and their performance shows how unfair the system is. This law will make it clear in the state of New York there is no option to an employer. You pay the same that you would pay a man, you have to pay a woman for the same work in the state of New York. It changes the old law, which had a loophole, which employers could say, well, it was not equal work, it was similar work. And if there was any difference, the law didn't apply.
Now, Senate Majority Leader Andrea Stewart-Cousins says, quote, white women earn 89 cents to the dollar earned by men, a gap that is even more pronounced among women of color, with black women earning 63 cents and Latinas earning 54 cents for every dollar. Well, the governor also signed legislation barring employers from asking prospective workers about their salary history, which he says puts women at a distinct disadvantage. Now, this is especially relevant for women who temporarily leave the workforce to start their families. This all comes as there are more new laws now designed to protect women from another issue in the workplace, sexual harassment. All right, here now to discuss what the state's new workplace harassment laws mean is Catherine Barcroft. She is the special counsel for the Solomon Law Firm. Thank you very much for being here with us on Empire State Weekly.
Thank you for having me.
And you've represented people on both sides of this issue, and now we're seeing the law's been made much stronger. What aspect of it do you think is going to prove to be the most significant in the ways that it's been made stronger?
I think the most significant aspect of it is lowering the standard for a hostile work environment for sexual harassment and other types of discrimination. So at the federal level and previously in New York State, although not in New York City has always had a more progressive law, you had a severe and pervasive standard where in order to establish a hostile work environment, a victim would have to allege that the conduct was sufficiently severe or pervasive to create an abusive environment that alters their working conditions, and a court would look at the totality of circumstances, the frequency of the conduct. Now the standard in New York State, in line with also New York City, has been lowered, so an individual victim just has to prove, if they're part of a protected class, that they've been encountered inferior conditions that have altered the workplace. So they've been treated essentially less well than other people in the workplace that are not in that protected category. Another part of this is that one of the affirmative defenses is that it does have to arise to more than petty slights or trivial inconveniences. So it does have to be significant, but it's not as high as a severe and pervasive standard. There's also an elimination of the defense, the fair health defense, and that means essentially that if an employee doesn't necessarily file an internal complaint that's investigated and filled out all the forms they need to fill out, they may still be able to bring a sexual harassment claim successfully or other discrimination claims successfully.
The things that you're mentioning, a lot of them are very nuanced. So is this going to actually make it harder to prosecute in these cases?
I think it's going to make it a lot easier. I think that
Okay.
it's going to be easier for victims to get into the courtroom to have verdicts in these types of cases, because you're not going to have to prove that all this very long pattern of discrimination or sexual harassment or hostile work environment. In fact, even one action could be sufficient under the new law if it's severe enough. Not if it's severe enough, but if it's considered you're treated less well or inferior. So I think it is going to help victims get into the courtroom.
This affects companies all over New York State, whether they're large corporations or I guess even if you have 1 or 2 employees. Is that right?
That's correct.
Yeah.
It applies to any company with even
Yeah.
one or more employees. So it is a very expensive law.
So in the past, a lot of companies who've come across this have settled things quietly and done things quietly. There are some changes in the law that kind of remove that with the non-disclosure issues. Explain those to us.
Right. So this is sort of the second wave of legislation in response to Me Too in New York State. And there was already some legislation about non-disclosure agreements and the fact that now it has to be an employee's preference to enter into a non-disclosure agreement and a settlement agreement regarding the facts and circumstances related to sexual harassment that you're settling the case about. So now these types of non-disclosure agreements apply to all discrimination victims, and it has to be the employee's preference. And there's a 21-day waiting period. So if you're provided with a settlement agreement, you have 21 days to consider whether or not you'll sign it with this non-disclosure clause. And you also have 7 days to revoke it. It's similar to the Age Discrimination Act. If you have if an employee is over 40 years old and they execute a separation agreement, you also have that 21-day waiting period and 7-day revocation period. So it's similar to that type of law.
Also, for employers, it used to be that the employee had to come and let them know if there was a problem, right? And hasn't there been a bit of a change now with this law that people will still be able to, whether or not they brought that complaint to their employer's attention?
Yes, that's exactly right, and that's what I was speaking about with the elimination of that defense. Now, you should still, I don't want to say don't file a complaint. I think you should still, employees should still go and file a complaint, but an employer can't escape liability just because they say, well, you didn't file this specific form, which is sometimes confusing for plaintiffs, right? Because there's a lot of forms on the website. Did they do it exactly right? So those are issues that really shouldn't prevent a plaintiff from getting into the courtroom.
On the other hand, though, for the employer, they may want to do the right thing, and if they don't know about it, they're in a difficult position now. I've seen people say that managers are going to have to be much more on the job and much more aware about what's going on, but what would you tell employers to do?
I think be proactive, know what's going on in your workplace. If somebody does report something to you, take it and put it in a form. You can fill out the form for the employee, make sure there's investigation done, be proactive, because it's important actually to have and also the training will help. The training which I spoke about previously on here, you have to have your training done in New York State by October.
Of this year.
Of this year. So it's coming up and it's very important, and that's a preventative measure as well. You also now under the new law have to hand, when you have a new hire, you have to hand that new hire a copy of your sexual harassment policy. So they're aware of what your policy is, that it's in compliance with New York State, and that's an important part of this as well that's came out in the new legislation.
All right, here's a simple question. If I'm a small business, I have to meet this October deadline to train my employees on sexual harassment issues. How do I do that? And where do I find help? Is there help?
There is help. There is a lot of help. It's all online. It's on the New York State website. You can even Google it. You can say, look, I want to learn about training policies. I want to see what I have to do. And it actually has a sample training policy on the New York State website. It has a sample policy, sample training, and as long as you meet what's online, or go above it if you want to.
What does training involve? Can I do it online, have people log onto a computer and do training? Do I have to bring somebody in person?
You could bring somebody in person, you could have it online as long as it's interactive. One of the requirements is that it's interactive. You have to provide hypotheticals. You'll see on the website that there's actually hypotheticals provided that you can use those hypotheticals in your training that have you answer, is this sexual harassment, yes or no? Is this, and sort of go through all the different facts and different stages of an actual real life scenario of discrimination and harassment.
Do I need an attorney and have to pay a lot of money to go through this process if I'm a small company?
I mean, I think it's always advisable to have an attorney, but you can go online. You can look at the procedures online, and as a small business, and if you're just in a business of even one or more employees, a small business, you can go online and look at these. That's why the New York State did that, because they want everybody to have these policies in place, and so while it's advisable to have an attorney, you can do it by looking at sort of the website and going through what the requirements on there.
We're about out of time, Catherine, but you can find all this information online on the state's website and be useful, especially if you're a small company who's worried about how to pay for this. We've been talking with Catherine Barcroft from the Solomon Law Firm about sexual harassment training and the new laws here in New York State. Thank you again. Well, coming up, Governor Cuomo signed another law this week that might not be getting as much attention as most, but it could reignite New York's ongoing battle with the Trump administration. Welcome back to Empire State Weekly, everyone. I'm Tim Lake in Albany. Governor Cuomo has now signed legislation making it a lot easier to get a hold of a public official's tax returns, state returns. The bill passed by state lawmakers in May allows the state tax department to give congressional oversight committees access to state tax returns filed by the president and other federal, state, and local elected or appointed officials. Now, the law is widely seen as an effort to get access to President Trump's New York State tax records. Coming up on Empire State Weekly, several months after the state vowed to kick Charter Communications out of New York State over broadband internet expansion, there is finally some closure in this long legal case. So what's next for the public utility that never delivered on the promise to expand high-speed internet across rural upstate New York? Finally, here on Empire State Weekly, New York's Public Service Commission has approved a $12 million settlement with the state's largest cable and internet provider after it tried skirting broadband responsibilities to upstate communities. Charter Communications will now have to expand high-speed broadband internet to 145,000 more upstate homes by the end of September 2021. That is estimated to cost some $600 million. Now, the PSC rescinded Charter's 2016 merger with the Warner Cable last year and threatened to kick them out of the state for failing to keep its promise to expand internet to rural upstate communities. So for now, for all of us here on Empire State Weekly, I'm Tim Lake in Albany. We'll see you right back here next week. And don't forget, you can watch Empire State Weekly all over New York State. Here now is the full schedule of Empire State Weekly on 10 TV stations across New York.